Today's topic is a specific type of injunction, that is Anton pillar injunction. Mainly there are two types of injunction granted by the civil court. One is temporary injunction, and temporary injunction is regulated by CPC. Order 39 deals with it. It is granted in the meanwhile or during the pendency of the case or for certain period. And second is perpetual injunction, which is regulated by the Specific Relief Act. So, we shall not discuss in detail these two type of injunctions. Today, we shall discuss in brief the Anton pillar injunction. There was a case Anton pillar KG versus Manufacturing Processes Limited, reported in 1976 All England Reporter. It is order of the Court of Appeal of England and Wales. In this case, the plaintiff Anton Pillar KG, a German manufacturer of silent block, and plaintiff Anton Pillar discovered that the defendant, who is agent of the plaintiff, a Manufacturing Processes Limited, a English company, was sharing certain secret information with the two other German companies, Ferrostal and Leckmotoran. The plaintiff also came to know that the defendant is also negotiating or tried to negotiate with two other companies. One is Canadian company and another US company, and want to share the secret information and want to infringe their copyright over the silent block. So, the plaintiff filed a civil suit seeking injunction, seeking ex parte injunction, restraining the defendant, Manufacturing Processing Limited, not to share the secret information and the important information with other companies. And second relief is claimed that the plaintiff may please be allowed to enter into the premises of the defendant and to inspect the document and articles and to take custody of important articles. The plaintiff was granted one relief by the trial court, that is restraining the defendant, ex parte restraining the defendant from sharing the secret information, and second relief was declined. Therefore, the plaintiff Anton Pillar filed an appeal before the Court of Appeal of England and Wales, and his second prayer was accepted by the appellant court, but the court laid down four requisites for making such order. Number one, the applicant should have a strong prima facie case against the defendant. Number two, the actual and potential damage to the plaintiff by the defendant is serious. Number three, there is a clear evidence that the defendant has relevant and incriminating material or document or item in its possession, and there is a real possibility that it will destroy such material before inter party application is made before the court. And fourth is that should an order be made, it would not cause any real harm to the defendant. These are the four essential prerequisites for granting ex parte injunction and to allow the defendant plaintiff to enter in the premises of the defendant and to inspect the documents. This Anton pillar principles or this type of injunction was also granted by the Indian courts, and it is also known as John Doe order or Ashok Kumar order or Anton pillar order in India. There are two decisions where these principles were followed. Number one, Taj Television versus Rajan Mandal, 2003, Delhi High Court, and second is ESPN Software India Limited versus To Do Enterprises. So, this type of injunction, that is known as Anton pillar injunction, is granted where there is infringement of intellectual property right and it became necessary in the circumstances, otherwise the important document will be destroyed by the defendant.